Yes, hi.
Hi, is this Mr. Horowitz?
Yes, it is.
Okay, Mr. Horowitz, you're talking through the speaker system in the courtroom, and I'm going to check the other microphones to make sure that you can hear.
Okay, thank you very much.
Can you hear me now?
Yes, I can.
Okay, Mr. Horowitz, we're going to start.
Okay, thank you.
All right.
Attorney Paul Sella present for the plaintiffs, Jason Hester.
Good morning.
Good morning.
Yes, and Leonard Horowitz here, present as the defendant.
With regard to the motion to dismiss, Mr. Horowitz, is there anything you'd like to add to your written submission?
Yes, well, first order of business, Your Honor, is that having you state that the motion by Mr. Sola will be heard today, I object to this hearing on this new motion. Mr. Sola's plaintiff's motion for judgment on the pleadings for two important reasons. First of all, the court lacks jurisdiction to hear this case. And number two, the motion was never served on me. There was no affidavit filed by the plaintiff, both in violation of RCCH Rule 7. And so that rule covers the form of motions. It states all motions except when made during a hearing or a trial shall be in writing, and every motion except one entitled to be heard ex parte shall be accompanied by a notice of hearing or of settling of the hearing thereof. I never received that motion. The motion may be stated in the notice of the hearing. If a motion requires the consideration of facts not appearing on the record, it shall be supported by an affidavit. The motion does not carry an affidavit, to my understanding, because it's not listed on the Holy record now. I am in receipt of no such hearing notice nor affidavit. The service of the motion was never provided, thus seriously prejudices this defendant and these proceedings, notwithstanding the court's lacking jurisdiction for other facts known and corroborated by the public records that I've provided attached to my motion to dismiss, Your Honor.
Anything you'd like to add to your motion to dismiss?
Yes, Your Honor. I would like to state that the case must be dismissed in the interest of efficiency, economy, and justice, since besides the named parties residing out of state, precluding the personal jurisdiction of the court over these named parties, Mr. Sola has concealed his own real party of conflicting interests as evidenced by the public records filed with the motion to dismiss. Mr. Sola's HHLLC, also a concealed real party in interest, was concealed from the court and the defendant at the time the complaint was filed. Mr. Sola purportedly purchased title and interest in the subject property secretly in the name of HHLLC, making him the exclusive real party plaintiff. Mr. Hester, purportedly having sold the property and conveyed title to Mr. Sola, is no longer a real party in interest, nor is he even a resident or citizen of Hawaii, as mentioned in the motion. According to the affidavits filed with my motion, provided under oath by the process servers in Hawaii, California, and Arizona, Mr. Hester is not a resident or citizen of Hawaii. There are cases involved I did provide in my motion. Hano versus State, the Hawaii Supreme Court stated the, quote, crucial inquiry with regard to standing is whether the plaintiff has alleged such a personal stake in the outcome of the controversy as to warrant his or her invocation of the court's jurisdiction and to justify exercise of the court's remedial powers on his or her behalf. It's recording from Model versus Maya Hari, Hawaii, 2001. In determining whether a plaintiff has standing, the court looks solely to whether the plaintiff is the proper plaintiff, without regard to the merits of the allegation. Mr. Sola's motion is getting into the merits of the allegations, and we can't go there. We have to deal with a threshold matter of jurisdiction. Mr. Hester is clearly not a proper plaintiff since the res judicata case that is still in appeal precluded foreclosure, and Mr. Sulla's conversion of title was likewise precluded. Plus, any interest or title Mr. Hester could have invalidly claimed was lost when he sold the property to Mr. Sulla's entity, HHLLC. So Hester, a non-citizen of Hawaii, is not a proper plaintiff, with nothing to gain or nothing to lose by these proceedings. Nor am I a resident of the state of Hawaii. And as the only defendant, this court's jurisdiction, personal jurisdiction over the parties, is therefore lacking. And besides not having personal jurisdiction over the named parties, neither does the Honorable Court have subject matter jurisdiction over these Third Circuit Court matters. The title is still contested in the Third Circuit and appellate proceedings at this present time, Your Honor.
Mr. Hester, Mr. Horowitz, did you receive a copy of the plaintiff's motion for judgment on the pleading?
No, Your Honor.
Mr. Sulla, it was not sent to the correct address according to the certificate of service. Was it served on Mr. Horowitz?
That's not correct, Your Honor. It was served on him, sent to him on two of his addresses. The one in California that he now allegedly lives in, and the one in Honolulu, which he used when he filed the action.
The one in California is not the same address.
Well, it came back. The California one came back. The Honolulu one did not come back.
But the California one was not sent to the correct address, correct?
Well, it's sent to the address that he put on his motion.
Sent to 200th Street, not 220?
1458.5 is what it says on it.
West 220th Street. And the motion was sent to 200th?
Yeah, it's west 200. Oh, 200. Well, it didn't go to, Your Honor. The one in Honolulu did go. He has a Honolulu address also. He used it when he filed his action. He used it when he's gone to federal court to remove the action. They used it when they decided he wasn't a resident of Hawaii. He was not a resident of California, which is what he tried to do in one of the diversity actions, which I can show you the findings in federal court. So now he's claiming he's in California. But it was sent to him in Honolulu. I spoke to him about this. I know he received it.
That's a lie, Your Honor. Mr. Sulla...
Okay, thank you, Mr. Horowitz. Mr. Sulla, Mr. Horowitz personally served with the original petition.
Yes.
Was there an acknowledgement of service filed in the federal court when the case was removed?
Well, he removed it to the federal court.
I understand that, but when a case is removed to the federal court, the circuit court doesn't receive copies of the documents that were filed in federal court.
Okay.
So the First Circuit Court pleading file does not contain service documents with respect to the original petition. Mr. Horowitz alleges in the motion to dismiss that one of the deficiencies in this case is that he was served by certified mail with the original petition at the Honolulu post office box.
So he alleges that.
In the motion to dismiss, and attaches the certified mail.
So that's
Under Rule 4 of the Hawaii Rules of Civil Procedure, the initiating document is supposed to be personally served, unless you have leave of court to serve by certified mail, but this court did not grant leave to serve the initial document by certified mail. So the court is asking you whether you personally, the original petition was personally served on Mr. Horowitz.
I'm not sure, Your Honor. I believe it was personally served. I also thought this was a written procedure. This is a filing with the European Bank.
It should have been filed as a special proceeding, not as a regular civil proceeding.
Should have been, yeah.
To this court, you filed it as a regular civil proceeding. Even if it was filed as a special proceeding, personal service of the initial document is required.
I can't do anything about the COVID record until I can find Mr. Horowitz.
So what the court is going to do at this point is, with respect to the motion to dismiss, the court grants in part as to the change of venue, and orders that the matter be transferred to the Third Circuit. With respect to plaintiff's motion for judgment on the pleadings, that motion is denied without prejudice, as the defendant has not been personally served with the original petition.
So, we're going to do this then again in the Third Circuit. I'm going to move this to the Third Circuit now. Is that what the court's basically?
The court is.
That, he claims he lives in Honolulu. He filed everything in Honolulu. I'd rather be the Third Circuit. I live in Cuba, but I came here because of this allegation that he doesn't feel anymore. He doesn't live on the Third Circuit that he made in the federal courts. Now he's saying he's in Honolulu, so that's why I came here. And he filed this motion now to say I want to go back to the Third Circuit, which I would have done originally and had no problem with this in my motion. Okay. So this case will be moved into the Third Circuit now? Is that what it has?
Yes, so Mr. Horowitz, you need to prepare an order granting in part your motion to dismiss, changing venue to the Third Circuit, also an order denying plaintiff's motion for judgment on the pleadings without prejudice.
Thank you.
Court will be in recess.